Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
My name is Jason Lazarus, Chief Executive Officer of Synergy Settlement Services, and I'd like to welcome you to this month's Third Thursday webinar. Our topic for this month is 2. We have protecting the most vulnerable settlement planning issues for personal injury victims. I'll do a very brief intro and overview of that, and then our guest speaker is going to talk about qualified settlement funds, which are an invaluable tool at settlement for protecting these same classes of clients. These issues are ones that most trial lawyers are not real familiar with, but can really help streamline when you have a complicated catastrophic settlement, getting that case to the finish line. In terms of housekeeping for today, there'll be a brief question and answer session at the end. There is a question section in the webinar where you can enter questions if you do have them. The webinar is being recorded today and will be posted electronically to watch again. And if you'd like a copy of the PowerPoints used in today's presentation, send an email to info@synergysettlements.com. Before beginning today's presentation, let me tell you a little bit about Synergy Settlement Services. We provide efficient healthcare lien resolution, Medicare secondary payer compliance, settlement consulting and government benefit preservation, structured settlements and other financial products, trust services, and lastly, tax deferral mechanisms for contingent legal fees. Everything that arises at the end of a case that can be complex and cause issues with getting the case to compliant resolution are things that we can assist with. Before getting into the topic on qualified settlement funds, I wanted to briefly touch on the blog post for this month on protecting vulnerable clients and the why, because clients that are catastrophically injured are different, they have different needs and more complicated issues that arise at settlement. What makes catastrophically injured clients unique and different is that they cannot tolerate a one-size-fits-all approach because they have so many complexities they face when resolving a personal injury case. They have to figure out how they're going to get health care. Is it going to be through private health care? Is it going to be through government assistance programs such as Medicaid and SSI? All of those different types of issues need to be addressed by an expert planner that is focused on solutions that are holistic for that particular client. Someone that sees every problem as a nail is going to use a hammer. The problem is that that type of approach in a catastrophic settlement just does not work. You really need a settlement planner well-versed in all of these issues to make sure that the client is protected, to make sure that you're protected against malpractice risks, and to make sure that every I is dotted and every T is crossed when that plan is complete for that client. And it's a plan that will last for that client's entire life, because oftentimes clients are on different types of government benefit programs, Medicaid and SSI, which implicates the use of special needs trusts, which can be pooled or standalone. Sometimes clients are on Medicare and SSD, which implicates the Medicare Secondary Payer Act and Medicare set-aside trusts. Sometimes clients are dual eligible. They get Medicaid and Medicare, and then there's more planning that needs to be done. And then lastly, just managing the recovery, making sure that there is a framework in place to protect that recovery. It could be trusts, could be a lot of different combinations of products with structured settlements involved. There's simply too many details to leave it without proper planning. When settling a case for someone that's been catastrophically injured and permanently disabled, planning becomes vitally important when the case is resolved, because you want to make sure that their government benefits are protected, because in most cases they're not receiving enough dollars to pay for all of their future care. So you need a supplemental fund that will provide for things that government benefits can never provide for. You want to have a system of advocacy to protect that client's quality of life. And also, you want to make sure you establish a long-term framework for management of the recovery, because this has to last for the rest of their lives. Moving on to the heart of today's presentation is qualified settlement funds, and the use of those in settling complex, catastrophic, multi-party personal injury cases is what I'm going to talk about briefly, and then our guest speaker is going to dive into in a great deal of detail. But the idea of this being a model approach to settlement is one that I think you should keep in mind when listening to today's presentation. In a nutshell, qualified settlement funds provide the time necessary and the breathing space to get the planning that needs to be done when settling a catastrophic case, because a QSF allows you to settle with the defendant as if it's a cash settlement, but avoid triggering constructive receipt by putting the money into a trust that's created pursuant to Treasury Regulations 1.468B. And really, this is just simply creating a holding tank for the settlement. It can be used in multi-party litigation. It can be used in single plaintiff cases with some limitations, but it gives time to do all the planning that's necessary and avoiding that crunch that comes typically at the end of a case. We are very lucky today to have with us an incredibly gifted speaker, Robert Wood. Robert is the managing partner of his law firm in San Francisco, California. He is considered one of the foremost experts on taxation of damages and qualified settlement funds. You can see from his bio, he's written extensively on these topics and is routinely published in some of the most respected publications across the country. I can tell you from working with Robert, he is a consummate professional who has a complete command of the types of issues that he is going to discuss today. So without further ado, I will turn it over to Robert.
Thank you very much, Jason. This is Rob Wood. And let's see, hopefully all of you can see the screen and also hear me. If there are any mechanical problems, I hope someone will jump in and help me. I am not the most technical person, but I'll do my best to, I guess, speak to the substance here in the time we have. My plan is to talk for about 35 minutes or so, and then take questions, which and if there are no questions, I will ask myself some. Qualified settlement funds, before we talk in substance, I want to give you references to a few resources. I realize in looking at the slides here that that there are an awful lot of resources that I didn't reference here that I at least want to mention. Starting, I guess, on the cover, if you, the website, Wood LLP, my email address and phone number, direct phone number are there, and you're welcome to send me questions or ask me questions by phone. And if your question is one I can answer, I will. If it's something that is more involved and I think you need to hire me, I will tell you that. So feel free to contact me. The website, I think, is good because there's an awful lot of content there that you can download for free. So if you sort of click around at woodllp.com, you'll find taxation of damage awards, of course, but there's also a tab, I think, under practice areas for qualified settlement funds. And there are many links to articles there, which I guess it would have been good if I had put on a slide for you. I think I referenced a few of them later on in the slides, but there are many of them there. And some of them cover essentially the same material that I'm going to talk about. But if you want a convenient couple of page reference to stick in your briefcase or something to give you kind of a short rundown of what QSFs are, how you can use them, you might look there on that QSF Qualified Settlement Fund tab. I pulled one this morning that I now remember writing. It's from 2010. Called 10 Reasons Not to Form a Qualified Settlement Fund. And it goes through, it's sort of common objections that, and frankly, I used to hear more of these around about 2010 than I do these days in 2019. But if you do have people that are saying, gee, I don't want to do that, or it's a problem, why should I do it? You might look at that one, 10 Reasons Not to Form a Qualified Settlement Fund. By the way, one other thing you can do on my website, and I know this from personal experience because I can never find anything when I want it. If you looked at my desk, it's piled with papers, and that's usually the way I work best, but it sometimes is challenging to find things. But there's a search window on our website, and so I'm commonly remembering that I wrote something or remembering that there's something somewhere on the website, and I'll remember a couple of key words from it. Obviously, QSF or Qualified Settlement Fund would work in this case. But I remember writing, for example, an article a year or so ago about the Roundup cases, and I remember weed killer as one word is in the title, so I always find it that way by is just typing that into the search window. So let's see, a website I've told you about, and I want to go on to, let's go on to some QSF basics. So what is it? Actually, Jason already did a good job, I think, of saying what it is. It is really something that I view as being an interim step. It doesn't solve all your problems, but as Jason quite correctly noted, one very common problem that many trial lawyers, I think, worry about a little bit, but probably should worry about more, and that is constructive receipt. It's a tax doctrine. And I think sometimes people confuse constructive receipt and actual receipt. I mean, if someone hands you money and you're holding it, it isn't constructive anymore, it's actual, you've got it. So you don't sort of need any fancy tax doctrines. And by the way, this is sort of an unhappy subject for many of you, I expect, but in general, the IRS views you as a lawyer as having money when your trust account has money. So and occasionally there may be ways of getting around this, but you need to hire somebody to help you in this circumstance, in my opinion. But just as a basic principle, if you settle a case and you get $1 million into your trust account, 400,000 of it belongs to you or will belong to you, and 600 to the client. the IRS view, which I think is mostly right, frankly, and it is the presumptive rule. I've seen it, I don't know, thousands of times, is you have on that day, you have $400,000 of income. And as I say, occasionally you can get around it, but and you may think, just as a bookkeeping matter, and from a sort of a state bar perspective, you may be right, that it's really not your money until you disperse it, until the client signs something like a sort of a fee reconciliation or a costs or disbursements report, something like that. Most lawyers have something like that. And you can make that argument, and I've done it successfully, but in general, you don't want to be in that position. And by the way, the worst thing for many people, and I've seen this too, as many of you probably have, and that is you get some huge case, and it's, let's say really big numbers, and you didn't know it was going to come in. You knew it was going to come in sometime, and let's say it's not even a settlement, so it's a judgment. You have no control, and you get it December 27 or 28. So, I mean, those things happen, and if you're a calendar year taxpayer, you can scramble. Once again, if you were in a qualified settlement fund, you wouldn't have those issues, because a qualified settlement fund is a cure to constructive receipt. It is a little bit, I guess, surprising if you dig into the authorities. I've actually written legal opinions on this, that it really is true that a qualified settlement fund, even though we all may know that you as a lawyer or your client as a client may be able to call up the friendly qualified settlement fund trustee and say, okay, I want my money today. And in most cases, it's not just calling up, it's also signing a form saying, there's $1 million that is sort of earmarked for me, and I need $500,000. So please disperse it, and I may structure the other half or something of that sort. And the idea, though, from a tax perspective, is there is a trustee, there is an administrator, and the qualified settlement fund is administered by usually a court, a governing government body, and that's what gives you the sort of remedy for qualified for constructive receipt. By the way, sorry to mention articles again. If you type in the topic constructive receipt on my website, you'll get a couple of articles that I think have a number of examples about trust accounts and lawyers and so on. And the reason, by the way, that you don't have to worry about constructive receipt if you're sort of poised with a pen over a settlement agreement, but you haven't signed it yet, is exactly that. You haven't signed. So for those of you who structured lawyers' fees, lawyers who've done that in the past or are thinking about doing it, it's a little bit of a confusing topic, I think, because if you are poised about to sign a settlement agreement, and by you, I really mean your client, it's the client with a typical contingent fee. I mean, you might be approving a settlement agreement as to form, but you're not the party signing and releasing legal rights. The client is. So the client signs it, and at that moment, the client is entitled to the money, and you're entitled to your share of the money. So, and the settlement agreement will say, presumably, when the money is going to be paid, but it might say the money is going to be paid within X number of days. That would be typical. Or it might say the money is going to be paid in 2 installments, one now, and as we get later into the tax year, this comes up a lot for me. I imagine it does for you too, which is, do we want the money this year, or do we want it next year? Or do we want the money split between years? And lawyers and clients can have discussions about that and can agree in a settlement agreement. And defendants, in my experience, not always, but I'd say 9 times out of 10, they're happy to do that because they're just paying the money a little later. Usually they don't care. But The reason I'm stressing this is that if you say in the settlement agreement, this is how the money is going to be paid, and then you sign it, there's no constructive receipt issue. Yes, it's true that you could have insisted on cash, all cash up front, but you didn't, and you conditioned that agreement on your settlement agreement on the payment when you want it. It's like selling your house. You could agree to sell it for cash, or you could agree and insist that you're selling it on an installment basis. So anyway, QSFs, if this is too much of a headache, QSFs are sort of a get out of jail free card for this whole confusing doctrine of constructive receipt. So the money goes in, and how is it formed? They're traditionally, you go to court, and I suppose most frequently in the old days, you went to the court where the court that has jurisdiction over your case. Your Honor, we want to put the money in a qualified settlement fund. We're not sure yet. The plaintiffs need to structure their various liens and this kind of thing. And so it was kind of an open dialogue. You submitted a motion, you submitted a proposed trust agreement, and you submitted a proposed order. And most of the time, in my experience, that went swimmingly. Everything got signed, everything was done. And there are various forms around, and I have a book on qualified settlement funds that has forms in it. But there are also commercial providers now that will sort of set up quickly a qualified settlement fund for you. And I would say one topic, which is controversial sometimes, is what happens when you say to the defendant, look, we're not sure yet. The plaintiff needs time to structure. We're willing to have you pay. We'll give you a complete release. But as you'll see in the settlement agreement, it's going to say the money goes into the XYZ qualified settlement fund. That's who you're paying. And you can, and by the way, even if it's a PI case, the defendant can 1099 the QSF if it wants to. That happens a lot. Sometimes there are fights over 1099s, but one solution is to just say, fine, do whatever you want, because actually it doesn't matter to the QSF. So what do you do though if the defendant says, no way, we're not putting this money into a qualified settlement fund? I mean, I've been involved in those fights. Usually there's not a good reason. Often, in my experience, not to name names, but AIG is an insurance company that, for reasons that I've never quite understood, hates qualified settlement funds. And I'm sure some of you may know some of the sort of inside scoop as to why they do that, but they sometimes fight it in court. So, I mean, you could have a fight, but most times if you say money to the XYZ QSF, no one cares. All of the money should go in. So, I mean, you do need to have a little planning time. I'd say these days, in the old days, you might have needed a week, you might have needed more, depending on how much time your judge required. But by the way, when I say it was most common to go to the existing court that has jurisdiction over your case, it's not necessary. You can go to somebody else, any other court anywhere. The idea is have a court. There are QSFs formed with governmental entities as the supervising authority as well, not a court. QSFs and legal fees, all of the money should go in, and there are some reasons for that, but the best practice is the settlement agreement will say the money goes to the XYZ qualified settlement fund, and it has all the other things that it would usually have, but it's going into this sort of repository. If you, as the lawyer, need the money today, then in my view, the appropriate answer is tell the QSF administrator that, but they normally can just have the money go round trip. So it all goes into the QSF and then it comes out to you the same day or the next day. Or the client may want money. Partial disbursements are perfectly fine. If all the money is going into the QSF to allow everybody some breathing room, that's perfectly fine. And there's nothing wrong with, again, there's no constructive receipt doctrine issue raised by calling up the trustee, writing the trustee and say, I need to pay the FedEx bill, I need to pay for these depositions, the client needs to pay something, or walking around money, please disperse X amount, and that's what they'll do. Let's see. I want to go to why did these things start in the first place? Jason referenced the regulations, and Section 468B of the Internal Revenue Code is the governing provision. It's fairly clear, although it's a little confusing because it was written at a time when these things were generally called designated settlement funds, or DSFs. I won't divert into that topic, but the 1993 regulations that Jason mentioned basically were the IRS, the Treasury Department, sort of morphing a DSF into an even better vehicle, which is the QSF. Why did these things exist in the first place? They were not for plaintiffs, and they were not for plaintiffs' lawyers. They were for defendants. And they were for defendants because many defendants under the tax rules were worried, appropriately worried, that they might pay millions of dollars into some class action where to some plaintiffs' lawyers and to some fund or escrow where the money would sit there for years. And this does happen today. The money would sit there for years and eventually be resolved and dispersed out. So why was that a problem? Well, in general, under the tax rules prevailing then and even today, it wasn't clear when the defendant got a deduction, and generally the defendant didn't get a tax deduction until the money went out to the ultimate recipients. So it was put there for defendants. For plaintiffs, obviously, the big benefit is buy some time. Get the defendants, which may be plural, by the way, out of the picture. And by the way, that's another good thing, is you want a settlement and you can settle with each defendant, and the money is going into this pot until you really know how big the pot is. And the pot is the QSF. So it allows plaintiffs and their counsel. So you can structure, I think all of you know this, I hope so, you can structure out of a qualified settlement fund. And the structure may be for the plaintiff, or it may be for the lawyer or the lawyers. It's a way of buying time to get some space. So I guess I'm going to skip over some of these examples because I think I've covered the substance of them. Trust account, I think I've probably beat that issue to death already. And it's, again, one that we can talk about. I guess on the issue of cases on appeal, this doesn't come up too much in my practice, but the bottom of this slide, which is what happens if you've got, you're trying to coax, if you're the plaintiff's lawyer, you're trying to coax the defendant to put the money in after a judgment, and let's say they appeal. And sometimes it's the defendants that are actually trying to do this. I've had some defendant clients that want to make sure that they can do it this way, and that this way is they'll put the money in, the X million dollars, and they want to deduct the money, deduct the payment, because they think what's going to happen is the judgment's going to get affirmed, or even more, in the positive category, meaning that the plaintiffs are going to get the money and the lawyers, is the case has already been affirmed on appeal, and they're petitioning the Supreme Court for a cert or something. So they want to pay the money, but they want to keep that possibility that they get the money back if they sort of throw a Hail Mary pass and it works. And a QSF works there too. And again, I've written opinions on this. It's quite clear that you can do that, and you can have this possibility of reversion based on events that you don't control. So anyway, very flexible. And by the way, in my experience, the IRS really likes qualified settlement funds. I've not had a problem with the IRS auditing one or taking issue with forming them. And I'll come back to that I guess I come back to that right now because of the single claimant issue. There has been, and if you sort of Google this term, you'll see it floating around, a surprising amount of controversy over this. The regulations say something about one or more, which sort of sounds like one or more should be okay. But there has been controversy over the years, for more than 10 years now. I'd say over the past 5 years, maybe, it's died down to a whimper. For some years, I don't know, maybe 5 years, maybe about 10 years ago, the IRS was listing it as something they were going to give guidance on at some point. They took it off their list. I've talked to the IRS informally. The IRS doesn't seem to care. Some insurance companies seem to be, worried about it. And I would, again, cite AIG, not to name names. So, in my latest, which is now 5 years old, my latest article on this, which you can, it looks like you can click on this if you have a copy. And if you check that title on my website, you can get a copy of the article and read it. Okay, so timing issues. Oh, by the way, I guess I'm gonna skip over this. A timing issue. Some people have asked me, and I've done this a few times, can you form a qualified settlement fund when you don't have any money yet? And the answer is yes. You can basically have it sort of opening like opening a bank account and not having anything. But you can do that and sort of have it ready if you want. But once again, these days, it's usually possible to set them up quickly. And therefore, I think the need for that is less today than it used to be. So mechanics, I didn't really think to go over too many mechanics today, but things like, who should be your administrator, your trustee. Again, there are people that do it professionally. You can also have someone do it who's a trusted friend. Believe it or not, I'm almost hesitant to talk about this. There is no prohibition on being your own trustee. So you can have the Smith & Jones law firm trust account, which is, sort of your money, as I told you, your money and your client's money. You can have the Smith & Jones operating account, which is really your money in your law firm. And you can have the Smith & Jones Qualified Settlement Fund, and you can run it. You can be the trustee. It's a really bad idea, in my opinion. And I know that someday, maybe not in my lifetime, but someday, somebody is going to get in big trouble, and it's going to spoil some qualified settlement fund issues for a lot of other people. But there is no prohibition. You could be your own trustee. As I say, I think most people would advise against it. Certainly I would. Let's see. Speaking of doing it quickly, Synergy has one of these. There are pooled QSFs. I don't know if I guess that's my term, or it's a term that I've heard. And some law firms that are big plaintiff law firms that do mass torts and this kind of thing have these and may have several of them. I mean, there really isn't any clear authority, certainly no authority that says you can't do it, but there's no clear authority that says that these are fine. I have looked at it carefully. I don't think there's a problem, because to me, you have to sort of analyze claim by claim or case by case. Does it comply with the rules? And there's no, I guess back to my one or more comment, there's no reason you can't combine 3 cases or 100 cases. Some big law firms, I believe, tend to put them into certain categories, so that they put all of their asbestos cases in one, or they put all of their particular pharma cases in one or something. I mean, that's certainly fine too, but the idea is that you have a subpart, a subtrust of this trust. And again, nothing wrong with doing that. And once again, it can save time. accounting, and this is really the problem of administrators, and obviously somebody like Synergy, is they have to keep it all straight because, but that's their job, and to make sure that your money is segregated in terms of the accounting records and being able to show you when disbursements were done. But again, that's not terribly difficult. You just have to be able to do it. So I wanted, with, I guess, apologies for what I'm sure seems like I'm going off topic, I wanted to say for the last 10 minutes or so, what some things that you may or may not be aware of, but I think are important, that have changed what plaintiffs, lawyers, and clients see. And that is the so-called Tax Cuts and Jobs Act, which was the big tax bill, the so-called Trump tax law that passed around Christmas of 2017. So it kicked in 2018. So we're now, what, a year and a half or a year and 3/4 into it. The good news is most things about tax treatment of settlements and lawyers stayed the same. This article, if you click on it or get it from my website, I think will help you and may help clients. It's I think kind of a layman's or an easy, not technical version of how things are taxed when you get a settlement or a judgment. And it's updated with, so it's what, a year old now, this article. It's updated with the changes in the 2018 the Tax Cuts and Jobs Act. So you might want to look at that, because the main thing is tax treatment of legal fees changed a lot. Physical injury stuff, it's all the same. And when I say it's all the same, you probably all think you know this, and you do, I'm sure. Compensatories for personal physical injuries are tax-free, but the tax court is just full of disputes, and I see lots of IRS audits on these things. And sometimes they're easily resolved, but usually they're not pretty, and usually they take a while and they cost money. So I guess it's important to be sensitive to it and to try to steer clients in the right direction before they sign a settlement agreement, if you can. This chicken or egg article at the bottom is a really good one to read or to give to a client if you want, because I get I don't know, at least 5 calls a week on this very topic, which is how do you figure out sort of what's physical enough to be physical sickness or physical injury. And there are cases now in the employment context where there's no physical touching, there's no bruises, somebody didn't get hit or beat up, and there's no sexual assault, but going to work, the person says, exacerbated their medical condition, and so it got worse. And so, can you treat some of that as tax-free? And the answer is, in appropriate cases, yes. There's case law, but oftentimes figuring out what does the emotional distress come from involves this chicken or egg issue. Let's see. So here's where I think awareness for lawyers comes in. In the Tax Cuts and Jobs Act, lawyers' fees in general are non-deductible. And when I say in general, you don't have to worry about this. If it's a regular car crash case, no punitives, no interest, it's a case settling before trial. So you can, I think, reasonably confidently say it should all be tax-free. Traditionally, plaintiffs' lawyers and clients didn't worry about those. And that was right. I mean, it's from my viewpoint as a tax lawyer, if I'm ever involved in those, which I am, I always say the obvious. It's for personal physical injuries and physical sickness and emotional distress therefrom, and no 1099 to the client. Because I've seen cases where somebody is catastrophically injured and they get a 1099 for millions of dollars. I can explain it away on the tax return, and the odds of it being fine are high, but the client's got to spend money, and there is at least some risk of having a dispute with the IRS, even though you know ultimately you're going to win. So, and if the facts are less clear than that, it's more important to be careful. So if you have a PI case though with punitives or with interest, and I don't mean, with rare exceptions, I don't mean where you've asked for punitives in the complaint, but the case is settling before trial. I mean a case in which you went to verdict, you got a verdict for compensatories, you got a verdict for punitives, and then the case settles. And I see this a lot. An appeal might have been filed, and it might be bumping along, and it might settle during the appeals process, before or after briefing, or at some point, or it might be right after verdict that the settlement talks to start. But you've got a record that there are punitives, and if you or the punitives were not only possible but likely and at least awarded it by the jury. So if you have that, then you got to think about the tax treatment, because punitive damages are always taxable. So if your case settles for, the verdict is $5 million of compensatory, $5 million of punitive, and then you start talking and then you settle for $7 million, you can all see that issue, which is, hey, wait a minute, what is this? Can we say it's all compensatory? Maybe, it depends. Is 2 million of it punitive? Probably, it depends. Or because it was 50-50 compensatory and punitive at the verdict, is that 7 million split 50-50, 3.5 and 3.5? I assure you that's what the IRS would say. So what you want to do is get ahead of those issues. And why is that doubly important now? Because of the tax treatment of the legal fees. Here's this weed killer article. It explains it better than I can. If you work the math, you'll see that some plaintiffs in some of these cases end up almost losing money, if the punitives are all treated as punitive and the legal fees are non-deductible. So I guess one, sort of quick answer to this is settling is usually better. Employment cases, I don't know how relevant this is. A lot of controversy over this. There's still an above the line deduction in employment cases, so don't let people tell you there isn't. There was a lot of misinformation, I think, after the law passed at the end of 2017. If you have an employment dispute or a whistleblower dispute, and that includes False Claims Act, SEC whistleblower, IRS whistleblower, you get a deduction for fees above the line, and that means that deduction is still there. So back to my $1 million example, that means if the client's getting 600 in these cases, the client was taxed on only 600. I'm going to skip through this, but essentially, this is another good article, I think it is, highlighting issues for when people have problems deducting legal fees under the new law. And by the way, back to QSFs, it's not a panacea for this. It doesn't cure everything, but it buys you more time, and it often improves the situation on if you're having legal fee deduction problems. And by you, I mean the client. Okay, so whistleblowers covered that. There's another one about no deduction for legal fees. I think this is actually better than the other one I mentioned, because this is a longer article with a lot more examples in it. And let's see, so structuring punitives and interest, as I just intimated, there are new incentives to structure, and I think new incentives for QSFs. Mechanics, one thing about structuring and any settlement agreement is simply that you can address the wording. It doesn't bind the IRS, but it always helps. And you can address things like 1099. Who's going to get them? Is there going to be withholding? I right now have, curiously, I have a couple of cases involving settlement payments to foreigners, non-US persons, Canada or somewhere else. And, the question is, the defendant wants to withhold a whole bunch of money. And so there are ways to avoid that, but you want to have time to think about those issues and not just have the money show up with withholding, which I've seen happen, or show up with tax deductions taken out, like as wages when you're not expecting it. Here, I just referred to the flip side of this, the 10 things or 10 reasons not to form a qualified settlement fund. This is an article that is a more positive spin, 10 things I love about qualified settlement funds. I mean, this article is 11 years old, but I think it's still current, or at least, and I guess to the extent it mentions single claimants, it's probably outdated because most people don't worry about that anymore. But that's another good one you might want to look at. I didn't really cover the banks issue, but I should have. So the Supreme Court case, the Banks case, is now 2005, so it's now pretty old. However, it basically says something that a lot of clients have trouble believing, that when a case settles, the case is essentially treated for tax purposes as paid to the client, and then the client pays the lawyer. Almost every plaintiff's lawyer doesn't view it that way. Mechanically, it doesn't happen that way. All the money is going to be divided, and usually divided by the plaintiff's lawyer. However, for tax purposes, for the plaintiff, it's the plaintiff's case, the plaintiff's money, and the plaintiff is effectively paying the lawyer. So there is more concern. I mean, this was an important case in 2005. However, mostly people didn't worry about it so much because the client could always deduct the legal fees. As I said, that is no longer true. So there's a lot more worry now about ways to get around this. You really need to hire somebody to help you on this, hire a tax lawyer. But if you're having these problems, or clients are. And sometimes you need to sort of do a friendly amendment to your legal fee agreement. But focusing on settlement agreements and how you're treating the payments and the 1099s is really important. Sexual harassment settlements, I'm going to skip over. There are articles on my website. If you're representing defendants, which most of you probably are not, but if you are, you need to know that you can't deduct the payments anymore if it's confidential. I've seen a couple since the law changed that were not confidential for this reason, but 99 times out of 100, they're always confidential, and that means no deduction for the defendant for the settlement payment or the lawyer's fees. This big break one at the bottom of the page now is important because it says, and this was earlier in 2019, it says that you can now, the plaintiffs can deduct their legal fees. That probably should have been obvious all along, but there was a lot of worry over the last year that plaintiffs would not be able to deduct fees. Tax indemnities, there are a bunch of articles about that. It's a topic that comes up frequently. Not so much in PI, traditional physical injury cases, but in a lot of other cases. Every single employment case that I see always has some kind of tax indemnity language. So what do you do? This article, you do the best you can. And again, if anyone needs help on these things, you're welcome to call me. Consider taxes early. Consider structures early. I should have added to this slide, consider qualified settlement funds early. I view, I don't know, rightly or wrongly, I view structures and qualified settlement funds, we're sort of in the same breath because they so frequently help. I mean, it doesn't, a qualified settlement fund by definition can't hurt anything. And it almost always helps. I don't know how many times, just me as a tax lawyer, I'm not a plaintiff's lawyer, I don't know how many times I've seen a client get stuck with a structure that they bought, they arranged hurriedly the night before. The settlement had to be signed, and then a few months later, a few years later, they're really unhappy. And then they may, end up going to a factoring company and losing a ton of the money because they want the cash. Or conversely, probably an even larger number of times, I've seen people that couldn't make a decision and therefore figure cash is king, so they take a cash settlement, and then they realize the next day, the next month, that what they really wanted was staged payouts. And the same thing with lawyers, plaintiffs' lawyers, who some people do structured legal fees all the time for staged payouts. Some people have never done it, and then obviously some people are in between. But buying time is, in my view, almost never a bad thing to do. And that's it. I'm more than out of time, and I'll try to take questions. It looks like I may have lulled the audience entirely to sleep. So if anybody has questions they want to ask, please ask me. Unless I see something pop up on my screen, I'm assuming that's what's going to happen. I'll try to ask a few of myself. So one of them would be, I suppose, a controversial topic, and that is, okay, so I do this, so I put the money in, I buy a little time, I do that, and it happens, and the money is sitting there. Sort of, then what do I do? Well, then I think you, either yourself or with somebody who's qualified, you sit down and figure out what you want, and that may be you as a plaintiff's lawyer. It may be that you're facilitating your client. You may not be competent to sit down, if you're the plaintiff's lawyer, to sit down with a client. I'm guessing you're probably not competent, no matter how well you know the client, to crunch the numbers and to talk about life care plans and all that sort of thing. But there are professionals that do that, and you try to facilitate getting them what they want. Comparing options. It's like buying any other service. That's not a bad thing to do. So if you're shopping annuities, any structured settlement person, I think, is going to, with structure money, is going to shop different life insurance companies or other markets to see what's the best rate, what's the best rating, what are the rating companies, Moody's and Standard & Poor's and those things, what are the ratings, what are interest rates like, all those things impact what kind of a deal you get. I think these are important things because any structure, of course, once you set it up, you can't change it. So I guess back to my comment about factoring companies, you don't want to railroad somebody into having to make a decision so quickly that they end up with something they don't want, or with something that isn't the best choice. But suppose that you do this, how long should the QSF exist? They're really, once again, just like the strange rule that somebody can be their own trustee, even though it's not a good idea. There is no actual deadline on a QSF. I think a number of administrators, and I think this is a good rule, will say, we think if there's all sorts of controversy going on, and I have seen and am involved with some QSFs involving large amounts and large numbers of claimants, where the money has been sitting there for 5 years or more. And it's not that all of it's still sitting there, but there has been lots of controversy, lots of claims, and still many things getting worked out. So that can happen. That's not the norm, I'd say, these days. But once everything gets resolved, in most cases, it can happen within a year or so. If you have a small QSF, which let's say is the plaintiff and the plaintiff's lawyers. So I suppose you could say, and there might be some liens like Medicare or something, but let's say that that's really, two real parties in interest, two claimants, if you will. And the lawyer decides, you're the lawyer, you decide, oh, I've got other structures, and I'm going to just pay out the cash. I'm going to have the cash paid out to myself. Client's still trying to decide. I think if it's sitting there and it's been a year and it's been a full 12 months, so you're in the second year of the life of the QSF, somebody should start talking about closing it up. It's not mandatory, but let me put it this way. If you're still sitting, and let's make it personal, it's all the lawyer's money at this point. The client's been paid out. You've still got all of the lawyer's money sitting there, and it's 3 years later. I don't think that's a good idea. And I think even though I say constructive receipt isn't an issue, I think it's a potentially dangerous circumstance you shouldn't let go on that long. Okay, so somebody has asked the question, so let's see, how do you treat capital assets purchased by a QSF? I'd say I'm not sure I've ever seen it. I'd have to have an example. Can you depreciate? I don't think you normally should have a capital. You shouldn't buy a building in a QSF as an investment or something like that. So I'd say whoever this is, if you want to call me or email me, we can talk about it. Another question, we only do PI, so it sounds like it doesn't apply to us. Am I wrong? I'm not sure if that is referring to tax treatment of attorney's fees or QSFs. If you mean QSFs, no, QSF certainly applies to PI and many other kinds of cases, employment, for example. If you mean tax treatment of attorney's fees being a problem, if you only do PI and you never are asking for punitive damages or interest and you're not collecting those, then you're right. If it's truly a physical injury case only, then you shouldn't have trouble with the attorney's fee deduction problem. But if it's a case that is, say, intentional infliction of emotional distress, I guess without more facts, that's not a physical injury case. Therefore, you're not going to be excluding the recovery, and therefore you're going to have trouble with the legal fee deduction. Another question, would you suggest books and materials to read about tax treatment of QSFs for funds treated to settle CERCLA liability? Boy, good question. That's kind of an obscure one. I'd have to dig a little bit. I know I have a section in my tax treatment of damage awards book, and I think there may be a section that Qualified Settlement Fund book too talks about CERCLA. I mean, I've certainly seen environmental cases, and that's another sort of a great way that QSFs can be used as a fund for remediation expenses. So I've set those up. I haven't done one recently, but if whoever that is wants to contact me, I'll try to point you in the right direction. I think, by the way, this is a weird one. I have one more article to refer you to. So what do you do? And I suppose once again I'm naming AIG, but what do you do if you have a defendant that you don't even want to ask if they will, allow you to say in the settlement agreement the money goes to the XYZ Qualified Settlement Fund? What do you do? Can you, I've been asked, can you have a Qualified Settlement Fund that isn't named in the title Qualified Settlement Fund? I mean, tax lawyers like to be careful, belts and suspenders are always good. So calling something the XYZ Section 468B Qualified Settlement Fund, I mean, that checks all the required boxes. But what if you know that if you utter those words, you're going to be told, forget it, we're not going to do it. We're not going to pay that. We're going to pay your lawyer's trust account, period. So what about a settlement fund that says, the lawyer's trust, for example, and and I know that that's going to be a qualified settlement fund. And so I wrote an article, I think this year, I think it was in early 2019. If any of you can't find it on my website, it's called something like, a QSF that isn't called it's a cleverly named QSF or something like that. Anyway, it's an article. If you have trouble finding it, let me know. That basically steps through what I think are the rules and says that should work. There's nothing that says it doesn't. I'm always a little uneasy when I do that, but the goal, if you're representing your client, is to try to enable them to structure and not to please the defendant. So I think it's just fine if you need to do it. And I think that's the end of the questions. I'm going to thank you all very much, and happy to have you contact me if I can ever help.
That concludes today's presentation. If you need to reach me, want a copy of the slide deck, have questions, always happy to consult. My email address is on this slide, as is our toll-free telephone number. If you need help with a case, need a consultation, want to learn more, contact us toll-free 877-242-0022 or visit us on the web at synergysettlements.com. Thank you for attending today's presentation.